Madam Asia, me myself Hani Zulaika, together with my other group mates Farah Sakina, Nur Amni Irdina, Nur Atika Shahada and Nur Ain Zahira. Today in this video, we're going to present about a type of criminal defense which is unsoundness of mind. Alright, so firstly, when we talk about criminal defense, we must know first what is the defense mean. So in general, defense means something that is done or said to protect from attack or bad treatment. And besides, the Oxford Dictionary also provides the meaning of a defense that being used in a legal field. It is explained as an argument in support of the accused person in a court of law. Basically, in criminal, there are two categories of defense. When the wrongful act done by the accused has a justification or acceptable reason, the defense will fall under the first category, which is justification. Meanwhile, when the defense provided to the accused because his mental is not in the right state, it will fall under the second category, which is excuse. For unsoundness of mind, the defense falls under the second category. Now, moving on to the type of defense, actually there are a lot of defenses that can be used in court. For example, mistake, necessity, private defense, intoxication, accident, duress, unsoundness of mind itself, and many more. These are among the various types of defenses that can be raised by the prosecution upon the belief of his client impeachment. And as I said earlier, we're going to focus on the defense of unsoundness of mind. Therefore, to go in detail for this defense, I'll pass this presentation to Ami Irdina for her to elaborate further.
Assalamualaikum warahmatullahi wabarakatuh and a very good day. My name is Nur Amni Irdina and I will be presenting about the defense of unsoundness of mind. Unsound mind can be defined as a state of being mentally unwell. In other words, unsound mind can also mean a person who is incapable from his own infirmity of mind to manage his affairs. In a case that involves the question of the unsoundness of mind of the accused, medical evidence has to be established, but it is for the courts and not the medical man of whatever eminence to decide on that issue. The defense of unsoundness of mind is available in any criminal charges due to the features of unsoundness of mind being so subtle and lack of a standard of it or insanity. It is impossible to define unsoundness of mind, which may result in the lack of mens rea. Thus, it might be hard for it to be proved. If unsoundness of mind is to be determined as immunity, it has to be precisely defined. Defense of unsoundness of mind is recognized by the law and is covered under Section 84 of the Penal Code, stating in that provision is, nothing is a crime done by a person who, at the time of doing it, is incapable of comprehending the nature of the act or that he is doing something that is either illegal or against the law because of insanity. The particular provision is derived from the English principles which are outlined in the McNaughton's case. In this case, in 1843, Daniel McNaughton was acting under an insane delusion, claiming that Sir Robert Peel was persecuting him. He killed Sir Robert's secretary, mistakenly thought it was Sir Robert. He pleaded successfully on the ground of insanity and was not found guilty. However, there were many dissatisfactions arose from this verdict. The House of Lords, after debating the matter, was provided by the judges with a hypothetical case in the form of several questions. The answers to the questions are known as McNaughton answers or McNaughton rules. McNaughton rules has laid down two fundamental principles. One of them explains on the presumption of sanity, which says every person is presumed to be sane and to possess a sufficient degree of reason to be responsible for his crimes until the contrary is proved to the satisfaction of the jury. Another rule detailed in this case is relating to the defect of reason. To raise a defense of unsoundness of mind, it must be clearly established that the accused is performing under the defect of reason and from unsoundness of mind during the time he was committing the act. He did not realize or have the knowledge on the quality or nature of the action he was performing. Though he has the knowledge, he did not know the act carried out was wrong. Nonetheless, if the accused has the idea that the act committed was wrong, then he can be held punishable. On the grounds of this, in regards to having the McNaughton rules as the guidelines in raising a defense of unsoundness of mind, there are a few elements outlined by the English law based on the McNaughton's rules. First of them being the element of at the time of committing the act. This element explains that the court has to look at the state of the accused during the time he was committing the act. It must be shown that the soundness of mind arose or existed at the time he was committing the act. Into the bargain, the second element is the defect of reason. This means that the accused has to prove that he is suffering from mental illness or disease of mind during the commission of his act. That disease of mind has led to a defect of reason. The next element is not to know the nature and quality of the act. The accused must go on to show that he does not know the nature and the quality of the act he was doing due to his disease of mind. The court in its opinion stated that in the context of the nature and quality is referring to the physical character of the act, and we're not intending to distinguish between the physical and moral aspects of the act. Last but not least, the element that has to be acknowledged is the accused did not know what he was doing was wrong. This element is a saving clause whereby, though the accused has the knowledge about the nature and quality of his act, but if he did not know that the act committed was legally wrong, he can exempt it from any criminal liability. Next, I will pass to the next presenter, Farah Sakina.
Assalamualaikum and a very good day. My name is Farah Sakina binti Pardo Adras. I will be presenting on the topic of elements of the defense of unsoundness of mind under the Malaysian Penal Code. There are a few elements that need to be satisfied in order for the accused to raise a defense of unsoundness of mind. The elements can be acquired in one of the provisions in the Penal Code, which is in Section 84. This provision denotes that nothing constitutes an offence if it is committed by a person who, due to unsoundness of mind, is unaware of the nature of the act or that he is committing a wrong or an unlawful act during the time the act was committed. From this provision, the first element of this defense is at the time of doing it. The accused must be in the condition of unsound of mind during the commission of the crime. It will be pointless if the accused was suffering from the alleged condition before or after the act was committed, as it will not render the defense valid. The second element is by reason of unsoundness of mind. The accused must be suffering from any disease of unsound mind during the crime committed. According to J.K. Trivedi, it refers to a mental state in which the mind is not functioning properly. In most cases, a man is said to be of unsound mind if he is unable to understand others, express himself, judge the implication of his actions, or differentiate between good and bad, and also right and wrong. The third element is incapable of knowing. The accused must be incapable of knowing for what he has done. The condition of the accused must affect his cognitive abilities instead of his emotional or volitional abilities. The law will safeguard the accused who does not have the capacity to distinguish between right or wrong and legality or illegality. This is because a person who is unsound of mind might not have been aware of the physical nature of his act, including its moral character and legality. The fourth element is the nature of the act. The nature of the act under Section 84 of the Penal Code may refer only to a knowledge of the act itself and not the physical consequence of that act. However, there is a view that it can also be compared to the nature and consequence under Section 83 of the Penal Code, since both an act and its consequences are essential ingredients of actus reus and mens rea. The last element is the accused did not know he was doing what is either wrong or contrary to law. The accused must be asked if he was aware of what he has done and also if he knew his act was wrong or contrary to law. The phrase either wrong or contrary to law can be interpreted in two ways, which are disjunctively and conjunctively. Firstly, a disjunctive approach would imply that only one of the conditions need to be fulfilled to obtain the benefit of the provision. It would be sufficient for the accused to show that he did not know what he was doing was wrong or to establish unsoundness of mind's defense. Secondly, on a conjunctive approach, the accused must fulfill both the condition that he did not know that the act done was morally wrong and that it was contrary to law. The interpretation that can be drawn from this is that there are two tests and they should be understood conjunctively. That's all from me. I will pass to the next presenter.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Atika Syuhada binti Aladi, and I will continue explaining about the application of defense of unsoundness of mind in Malaysian cases. First, it can be further elucidated in the case of public prosecutor against Jegatisan Anak Lelaki Krishnan 2019. So in this case, the accused had killed the victim on 19th June 2014, and therefore he was charged under Section 302 of the Penal Code. The case was standard by the prosecution, and he was successfully established a prima facie case against the accused, since all the elements under Section 300 of the Penal Code were proven, and the punishment was provided under Section 302 of the Penal Code. So since the prima facie case had been made out, the court therefore called upon the accused to enter into his defense. On behalf of defense counsel, they had raised the defense of insanity and had tendered the evidence of two psychiatric reports which explained that the accused had suffered from bipolar mood disorder type 2. So the defense of insanity under Section 84 of the Penal Code had been raised by the defense counsel, as he argued that at the time of committing the act, the accused can be said as having unsoundness of mind. So the question here is how to establish that the accused had legally insane as well as medically insane. The court had provided two methods that need to be established or proved by the accused as underlined under Section 84 of the Penal Code. First and foremost, the accused must have unsoundness of mind at the time he commits the act. Second, the accused must be incapable of knowing the nature of his act or that he is doing the act which is wrong or contrary to law. The first element in this case has been established since the court found that the accused had suffered from a disease of mind which affected his mental faculty, and consequently his behavior was not normal at the time he attacked the victim. With regard to the second element, since the accused suffered bipolar mood affective disorder at the time he commits the act, the court found that he had lost his self-control and can be said to be in a rage embroiled with the victim, and consequently lead to the impairment of his volitional capacity and affected his cognitive ability to understand the consequence of his action. He believed that his attack was not wrong, and based on the evaluation and evidence tendered by the court hereby acquit the accused as the defense of insanity under Section 84 of the Penal Code was established. So that's all from me. I'll pass to the next presenter. Thank you.
Moving on, I will be explaining on the case of Zulkifli bin Majinji and public prosecutor. In this case, the appellant was charged in the High Court of Sabah and Sarawak with the crime of murdering the deceased. The appellant in his defense stated that he took shabu 4 times a month and that he could not remember what happened on the day of murder. He had also been hearing voices telling him that if he did not kill the deceased first, the deceased would kill him and cause him to raise the defense on unsoundness of mind. However, the appellant failed to produce any medical reports or other records to support his claim. As there was insufficient evidence, the defense failed to case any reasonable doubt on the prosecution's case. He was found guilty under Section 302 of the Penal Code and then appealed at the Court of Appeal. In the court decision, the trial judge in his statement stated that there are two matters that need to be considered by the court when the defense of unsoundness of mind is raised. The first one is the accused must be unsound of mind during the commission of the crime. The second one is the accused must be incapable of knowing his act as being wrong or against the law. As the appellant was found not to be reliable and truthful, the court held that he cannot avail himself of the defense under Section 84 of the Penal Code. The defense failed to prove the preliminary issue that at the time of committing the killing, he was of unsound mind. Therefore, the defense of unsoundness of mind was not established. The conviction was safe and the decision of the trial judge is affirmed. That's all from me. I will pass to the next presenter.
Assalamualaikum and good day. My name is Nur Ain Zahira, and today I will be presenting on the issues that arose from this type of defense, which will be the main discussion for my presentation. So the first issue that arose from this type of defense is whether those who are diagnosed with mental illness are incapable of thinking straight all the time, to the point that they deserve protection and excuses every time they commit a crime. The second issue is regarding difficulty in proving Section 84 of the Penal Code in court. Lastly, regarding provision at Section 84, which has a very broad and general definition, which is prone to different legal interpretation by the judges. The circumstances which led to this first issue is because of the existence of people who've been diagnosed with mental illnesses who are known to be succeeded in life. Example of those people are known as Abraham Lincoln, who is the former President of the United States, and also Eileen Sachs, who is an Associate Dean and Professor of Law, Psychology and Psychiatry at the University of Southern California. This shows that people who are diagnosed with mental illness are not necessarily being unable to differentiate between the good and the bad, and also is incapable of thinking straight all the time. Because of this, the court will have to take into account the circumstances surrounding the accused who pleaded for the defense of unsoundness of mind during the time when they committed the act, whether they deserve to be acquitted from being punished or not. Under the Malaysian criminal law, a person who has been convicted of a crime may raise a defense in court in order to acquit himself from being sentenced to a punishment. Hence, it can be said that all types of defenses are good defense, so as it gives another chance to the accused to prove that they are indeed not guilty. However, there may be difficulty in proving the defense of unsoundness of mind under Section 84 of the Penal Code. Challenges might arise in deciding some cases consistently with one another, as the provision itself is based on the bench judge's interpretation as well. This can be seen when previously the judges had applied the Magna rules directly in deciding some cases, which then has been criticized as this act went against the Section 3 of our Civil Law Act 1956, whereby our penal code has already provided defenses available to be used by the accused in order to defend themselves from wrongful accusations. Therefore, the judges should constantly refer to Section 84 of our Penal Code when giving their judgment in deciding cases involving this type of defense instead of applying the Magna rules directly. This is because any wrongful interpretation and application of the provision in deciding some cases may bring greater harm than good to the accused sometimes. This further leads to the question as to whether our Section 84 is flawless and sufficient to be used when an accused wishes to defend themselves under the reason of unsoundness of mind. And this is based on the grounds that this provision serves a very broad and general definition as to the true meaning of unsoundness of mind, and leads to the different interpretation by the judges, as they always have their own and different understanding in order to interpret this provision itself. It is very easy for an accused to be misjudged, further causing injustice to the innocent because of these wrongful interpretations. At times, the court will reject the defense of unsoundness of mind, even though the accused was indeed suffering from a legit mental disease, and this can be seen through the case of Sinasamy against Public Prosecutor 1956, whereby the accused, who suffered from an epileptic shock, which is a mental disease categorized as insane automatism, has killed his own daughter using a sharp knife. The court in this case, however, rejected the defense of unsoundness of mind, even though the evidence presented successfully showed that the accused was indeed in the state of epilepsy when he committed the crime, and the defense under Section 84 should have been valid for him. The court relies on the grounds that the wounds inflicted by the accused were too deep, which suggested that he has had to be conscious at the time when he committed the crime. Hence, from this case, it can be concluded that even though the accused suffered from certain types of mental disease, however, the defense of unsoundness of mind would not always be available to him and be accepted by the court as a defense, as whatever types of conduct and illnesses which are considered to be medically insane would not always be considered as legally insane. And that is all from me. This whole presentation will be concluded by the next presenter, Hani Zulaika. Thank you.
To conclude, based on the discussion earlier, we can see that the purpose of establishing this type of defense under the Malaysian criminal law is to protect the fundamental right of those who are truly mentally disabled from being convicted under the law, as it can be seen that these people are not able to distinguish between the goods and bad. However, as illustrated in the few cases discussed just now, we can see that this defense is prone to be misinterpreted if the judges are not careful when examining the fact of the case and the evidence presented. In addition, since Section 84 of Penal Code provides a general meaning as to what constitutes an unsoundness of mind, therefore, it is suggested for the Malaysian court to make a few amendments on this provision according to the current situation in order to provide fairness and justice to the society at the maximum level. Well, that's conclude our presentation. We hope that this video meet the requirement needed. Thank you and Assalamualaikum.